first case before us is In Re LF, LF, and JF. We only have one person here to argue, the appellant, so you'll have 15 minutes to present your argument. You may reserve, well, you don't need to reserve rebuttal because you're the only one here. Yeah, the arguments are being recorded. When you present your arguments, please introduce yourself, keep your voice up, and remain behind the podium. You should not use the names of children, minors, and victims during your argument, and you can refer to them by initials or terms like the child. We have read your briefs and are ready to proceed when you are. You may proceed.
Thank you very much. May it please the court, I am Alan Medvick, and I am here on behalf of the appellant mother in this matter, and we are appealing the decision to raise one assignment of error, that the decision to place the children in permanent custody of Summit County Children's Services was in error and contrary to the manifest weight of the evidence presented. The principal and really only prong in which we are arguing is that the best interests of the children weigh in favor of a 6-month extension, allowing mother to work toward reuniting with those children. All of the children stated that their intent was and their desire was to return to mother's home. All of the children at the time of the permanent custody trial were in separate homes, and none of the, possibly only one of those foster homes was a foster to adopt home. When we talk about one of the most significant prongs in what is in the best interest of the child is what is that is providing some sense of permanency to those children. And in this case, this decision has not offered any permanency whatsoever. As mother had asked at the time for a 6-month extension, the second 6-month extension, which would have granted a full 2 years to work on obtaining housing. Mother admits that she did not have housing at the time of the trial, but was in the process of improving her credit score and was on some wait lists with AMHA and other housing that could have resolved those issues. I think every person, every professional brought by the agency stated that the principal impediment to reunification was that lack of housing for mother, while the GAL and the caseworker both stated that they didn't believe there were other resources that they had to make available to them and did not have a reasonable explanation for why. We shouldn't allow these children who wanted to go back to their mother at least see if we could get to that time frame within the 2-year window of jurisdiction on these cases. I would also talk more broadly about that claimed 2-year jurisdictional window based on decisions out of the Supreme Court in this district. I would argue that that jurisdictional window has no effective meaning. This court and the Ohio Supreme Court have stated that even beyond 2 years, juvenile courts retain jurisdiction to make dispositional decisions regarding the children. I don't know what a jurisdictional limitation means if it does not mean limiting your ability to make dispositional decisions as a court. So the only permanent resolution in any ADN case at this point seems to be this, the permanent severing legally of a parent's rights to their children. Every other case can be brought back as a DN mod. Something else, the only permanency we have here, and the only permanency for any person, this includes the children here, is the legal termination of the parent's rights here. That has not been a permanent solution for these children in any way, shape, or form. They remain in agency custody, in foster care, in the continued risk, and while outside the record, I believe reality of disruption and relocation. The only person who would bring permanency to these children is his mother, and the only thing impeding her from getting those children back at this time was a continued pursuit and failure to obtain housing.
Counsel, can you relate to the court again what Children's Services Board did in regard to helping mother obtaining housing.
And they did provide resources. I believe they actually, early on in the case and at times, had provided financial resources and offered to provide first month down payment, security deposit. At that time, as indicated in the record, mother testified that she did not have a credit score, and her prior bankruptcies and her credit history was impeding her from even finding housing that was, she couldn't even get into door.
Did she present any evidence that she in fact did look for housing and was denied?
Beyond her testimony, no, I don't believe there's anything in the record to indicate that.
How about homeless, what they technically consider a shelter, but there's absolutely places where parents can live with their children
And
for at least
I'm not
90
aware,
days or so.
I'm not aware of anything in the record that from either side, that was something that was presented or an option for mother within Summit County or within the time frame of this case. And again, it's beyond the scope of this appeal whether mother has obtained housing now, but she was not given that opportunity within the time frame given, and we are now we're 6 months beyond when that jurisdictional deadline would have applied. I do believe mother has housing, but I don't know that I'm trying not to go beyond the record here. Mother has attempted to maintain those relationships with her children, again, even beyond the record. And I don't see, when you read this record, that these children wanted to return home. Mother had been working on her mental health crises that had led to this situation, to the degrading of her home, to the loss of home, to the bankruptcy, which were a result of mental health concerns relating to the suicide of an adult of her other child. And she has been working on those and dealing with that depression throughout this. And in many ways, I think she was, and her counselors, the people in the record, stated that she had made progress on that. And essentially, I think the resolution here puts a timeline on that treatment, and is a result, and creates a result that is not good for anyone. It is not good for the mother, and is not good or in the best interest of these children. And I think the record reflects that. The goals were to be engaged in mental health, or mental health counsel representative testified. I think both the caseworker and the GAL stated that even though she hadn't completed the last 2 sessions of the parenting class that was part of her case plan, they did not have concerns about her ability to parent. She had good relationships with her children, and she simply had not gotten housing. And I think that's stated again and again, that we are pulling the plug early on a case that could have been resolved by finding appropriate housing. I think is contrary to the weight of the evidence and contrary to what I think the goals of some county children's services should be. So with that, I would ask that you reverse the trial court's opinion and remand this matter to the juvenile court for further proceedings.
Counsel, can you remind me, JF is 14, how old are the other children?
And I apologize. I need to check. And I think JF is the oldest of the children. The others, I don't have those ages in front of me.
All right, thank you.
With that, I would rest for any further questions.
Thank you.
Thank you very much.
Thank you for your presentation. This court will take this matter under advisement and issue a decision in due course. The clerk of court will mail you a copy of the decision when it's released, and the opinions are also posted on the Ohio Supreme Court website.